Beautiful day in Philadelphia. It's not 6 degrees, so it's actually balmy compared to what it's been. I always love showing this because to me, this is a incredible, incredible piece of work that we're really proud of. But good afternoon, everyone. Thank you for joining us to celebrate the launch of this great publication, the Duane Morris Class Action Review 2025. My name is Matthew Taylor. I'm the chairman of Duane Morris. Besides our live audience here today, which there's many here in Philadelphia, we're joined by Zoom by a nationwide audience, as well as guests from overseas. We are so glad and grateful you're here. This is an exciting day for the firm, something that many, many people in the firm work on this publication, and we're very proud of it. How would one describe this one-of-a-kind publication? It's comprehensive, that's for sure. Just look at it, and you can see that. It's a comprehensive analysis of class action litigation, trends, and significant rulings and settlements from the past year that will enable corporate counsel and business leaders to make important and informed decisions when dealing with complex litigation risks in 2025. The review is 650 pages long, includes 23 substantive chapters with extensive charts and graphics and 7 appendices. It is designed as a reader-friendly research tool that is easily accessible in hard copy, like I have up here on the dais, and in ebook format. EPLIC magazine recent review said no corporate counsel, let me repeat, it said no corporate counsel should do without it. It went on to say it is an essential desk reference for class action litigation. The review is also a standalone, it also has, a standalone website, which includes succinct, high-level information, the top 10 trends in 2024, and the top 10 settlements in all areas of litigation. An executive summary, the video and video commentary. Take a look if you have not yet seen it. It's an incredible 3-minute tour of the class action world. Last year's edition of the Duane Morris Class Action Review was cited, and this is really, to me, very impressive. Last year's edition of the Duane Morris Class Action Review was cited in legal briefs to courts, with the review finding itself cited in a Wisconsin court ruling on a motion for class certification. Additionally, this past year's 2 settlement administration companies cited the Duane Morris Class Action Review's findings in their advertising campaigns, and 3 plaintiff firms, class action firms, cited the review on their website in touting their cases, talking about being thought leaders. The Duane Morris Class Action Review is also making an impact internationally, as the findings were also profiled in publications in 2024 and this past month in Europe, India, and Africa. As for the newest edition, published earlier this month, the response from our clients and the media has been incredible. Some administrative notes before I introduce Tom Servadidio, and these are really just housekeeping notes for the webinar. All participants are in listen mode only if you're here virtually. Listeners on the webcast are encouraged to ask questions and may do so by using the Q&A feature on the right side of your WebEx screen. All questions will be reviewed, and if the presenters are unable to answer the question live during the webinar, they will follow up with you afterwards with phone calls or emails to address your questions. For everyone interested in CLE credit, there will be a verification code given in the middle of the webinar. Please copy the verification code, as it will not be given again later in the presentation. Copies of the webinar materials and the video recordings of the webinar will be distributed to all attendees following the presentation. So there are just some housekeeping notes. But without further ado, I do want to acknowledge a couple of people. We have Eve Klein here from New York. Eve is the chair of our excellent and really talented employment labor, immigration, and benefits practice. Eve, welcome. And many of our Duane Morris colleagues are here, from our lawyers to our business development folks. Thank you for your hard work, because I know many of you worked hard on this publication. But without further ado, I invite Tom Servadidio to come up. Tom is not only our firm's vice chair. Tom was a longtime chair of our employment practice. Tom's a preeminent labor and employment lawyer himself, and Tom will have the honor to introduce our very distinguished panel here today. So thanks for your attention and enjoy the webinar. Thank you.
So I have the pleasure of introducing our speakers for today's program. First is Amanda Bronstad, who's here with us today from California. Amanda is an ALM reporter covering class actions and mass torts nationwide. She has an incredible following and writes the email dispatch law.com class actions, critical mass. In 2010, Amanda started writing about massive numbers of lawsuits filed against Toyota, claiming their vehicles would suddenly accelerate. That sparked a path to Amanda's current expertise covering mass tort litigation and class actions for ALM, which includes law.com, National Law Journal, and American Lawyer. We are so grateful and honored to have Amanda join us today with this book launch. Next, let me introduce Jennifer Riley. She's a partner at Duane Morris and vice chair of our class action defense group. For more than 2 decades, Jen has defended companies across the nation when they are faced with significant, complex litigation matters. She has handled some of the largest class actions in federal and state courts across the country. She's known for her thought leadership on class action issues and is one of the top 10 published attorneys in the country in this space. Jen is the co-editor and author of the Class Action Review. And last but not least, allow me to introduce Jerry Maatman. He's the chair of the firm's Class Action Defense Group and co-editor and author of the Class Action Review. With nearly 4 decades of experience practicing law, Jerry has defended some of the most significant bet the company class actions ever filed against corporate America. Among his cases, Jerry has defended and defeated the largest systemic enforcement action ever brought in the history of the Equal Employment Opportunity Commission, the first attorney general prosecution of a Wall Street company for workplace discrimination and harassment, and the largest wage and hour class and collective actions ever brought in states such as Florida, Illinois, and New York, among others. The author of 8 books on the law, he has served as a legal commentator on PBS, NPR, MSNBC, CNBC, and U.S. Talk Radio, and his comments have appeared in such publications as the Wall Street Journal, The Economist, and USA Today, among others. Jerry was also honored by ALM to be selected for the 2nd year as the author of the newest version on its publication entitled Class Actions, the Law of 50 States, which is a flagship publication of ALM devoted to class action law and practice. He is a recent recipient of the Law 360 MVP Award for Employment Law, which is his 8th such honor from Law 360 since 2013. Winners of this accolade have distinguished themselves from their peers by securing impressive successes in high-stakes litigation, complex global matters, and record-breaking deals. Overall, Jerry Maatman has received more Law 360 MVP awards than any other attorney in the United States. Finally, Chambers selected Jerry as one of the nation's leading class action defense lawyers in its 2006 to its most recent 2024 rankings of U.S. lawyers. And in its rankings, Chambers has stated, quote, Jerry Maatman is absolutely phenomenal and is one of the top class action minds in the country, close quote. And now with that, I'll turn it over to Amanda, then Jen, then Jerry. Each will provide their thoughts and analysis for 15 minutes or so, and then we'll have a Q&A session. So please enjoy.
All right. Can everybody hear me? Start with that. So yeah, He already gave a little bit of an introduction, but I do not have a law degree. I always start with that because everybody always asks me that question. But I've been covering law since 2006 for ALM, and for some publications before that. ALM has a number of publications, but I was wanting to mention the one you guys probably know the most about, which is the Legal Intelligencer. And so they also do the National Law Journal, law.com, American Lawyers, a number of publications. So um, I write about class actions. I also write about mass torts, and I was told to just include a little synopsis of both of them. So some of the things that I've written about repeatedly, some of the mass torts that have really gotten a lot of my coverage. One of the big ones, opioids. I know this is kind of sort of wrapped up, but there was the big multi-district litigation in the Northern District of Ohio. I wrote about a number of the settlements that came out of that and a lot of the trials. There was just recently a big news story that I wrote about involving 15 attorney general actions that were settled with Purdue after the United States Supreme Court dismantled the original deal because under the bankruptcy plan or under the bankruptcy code, they had violated the non-consensual release part of that. Increasingly in mass torts, I am covering bankruptcy. So that's a really good example. I also wrote about the 3M earplugs. These are combat earplugs that were basically alleged not to work. People were getting ringing of the ears and deafness. And that was an interesting MDL. That was out of Florida. That one actually was one of the only MDLs that was doing bellwether trials in COVID. Everybody else was just shut down, but we kept doing bellwether trials. And then that one tried a bankruptcy route as well and failed. So that ended up being settled. So that's, again, another bankruptcy I've had to cover. Juul, electronic cigarettes, Roundup. I've written about the Roundup litigation. A lot of the federal cases have settled, but you will still see a lot of trials in state courts in Roundup. And that's kind of going both ways. I am actually starting to do more stories about sexual assault. This is a increasing mass tort because you see a number of claimants at one time. They're not necessarily class actions because they have various injuries, but the settlements are interesting because they craft them based on the injuries with, Ken Feinberg type of settlement programs, and then they make claims based on the type of injuries they had. Obviously, Boy Scouts is a big one. Again, another bankruptcy issue. But I did a couple stories about the P. Diddy cases, so that's another more recent example. I also write about mass disaster litigation, also a big mass tort. I'm currently writing about the lawsuits against Edison involving the California fire, the Eaton fire that just happened this month. And I have written about the Oregon wildfire cases. There are class trials. This is something I'm seeing more and more often that are happening up in Oregon and there. And it's very interesting because the class trials do talk about damages and how do you get juries to make damage awards that are really, frankly, very different from one another. So, and then there's also the Hawaii litigation as well. But it's not just wildfires. Mass shootings also are lawsuits I've written about. Bridge collapses, condo collapses. I'm sure you guys know which ones I'm talking about, but these all end up causing a lot of lawsuits against the same entity. And then I did want to plug, I have a colleague named Elisa Furman, who I finally got to meet in person this morning. She works out of Philadelphia for our ALM publications, mostly legal intelligencer, but she also writes about mass torts. She just focuses almost exclusively to Philadelphia Court of Common Pleas, but she's also covering the Ozempic MDL, which is here in the Eastern District of Pennsylvania. So she's a really good resource for the local folks here. On the class action front, I am incredibly busy with data breaches. And I know this was in the book. There was a lot of mention about the fact that, okay, there are more data breaches, but I also think there are different kinds of data breach lawsuits out there. I see ones that involve a lot of these hub and spoke type of data breaches. So Snowflake, CrowdStrike, in these you have multiple breaches happening. So the question becomes who's the really liable party in those. Another case that I've been, seems like forever covering is the Marriott data breach. There's a class certification order in that case. And in data breaches, you don't see class certification orders that often. They don't usually get to that stage. So that order is up on appeal in front of the Fourth Circuit again. They've changed judges and it's been up several times, but it's significant because it is one of the rare orders out there. I am increasingly seeing privacy class actions. I'm sure you guys have seen these yourselves. There's a whole lot involving social media, AI, even something as simple as GM and Allstate being accused of collecting driver data in order to determine insurance rates. So those kinds of suits are very common in class actions that I'm covering. And then on the social media front in California, there's an addiction MDL that I think this is a really important case because if you look at the judge's orders, she has ruled multiple times on dismissal orders. And what she's done is she's parsed out social media to some really specific details about which one is covered by Communications Decency Act and which is not, or any other type of coverage. And it really gets into the minutia of how social media works. So I think it's going to make a difference in terms of future rulings involving social media by looking at how she spent, I mean, her rulings are very long. When she issues a ruling, I'm like, oh boy, there goes my afternoon, right? And they're very detailed, and you have to understand social media to sometimes understand them. But I think they're really, really influential. Also on the class action front, the DOJ has done a lot of actions involving antitrust allegations. And so I'm seeing a lot of class actions sort of parroting a lot of those, or sometimes the class actions are coming first. They're hitting a lot of industries like the sugar industry. I just finished a story about this is not my world, yacht dealers and their compensation being accused of being like a conspiracy theory, and the judge dismissed all of those cases. So some of these are involving algorithms, and what they're basically saying, and the way it was described to me, was instead of a bunch of guys in a boardroom smoking cigars and hammering out a deal together, it's this algorithm is the actual conspiracy. So what will be interesting is whether judges agree with that and how they're going to rule on that going forward. So that's why I think antitrust is an interesting issue in the class action front. I continue to do a lot of coverage about settlements. In Rule 23 actions, judges have been increasingly scrutinizing the settlement approvals, the attorney fees to plaintiffs' attorneys, the claims rates, the notices. And I'm usually in the hearing listening to the judge ask more questions and the lawyer's going, okay, we'll get back to you, because they don't grant a preliminary approval right away. And so that used to be like a few judges, and now I see it more and more. So I think there's just a lot of focus from them on making sure the class members are made whole, and they just want to make sure, you know, everything is okay before they grant any final approval. So, and you have a lot of objectors that are very active out there as well. So, and then the last area that isn't really, not really a mass tort or class action is mass arbitration. And I just finished a very interesting story about Tubi, the streaming service, had a class action settlement. In the middle of the settlement, there was a firm out of Chicago called Keller Postman, a plaintiff's firm that filed thousands of mass arbitration claims against Tubi. And Tubi's lawyers at Jenner and Block hired a former FBI investigator to find out whether or not those individuals knew that they had claims made on their behalf. And so the whole story became these lawyers fighting each other in really ugly ways, both ways. And it ended up in front of a federal judge in Washington, D.C., who, I mean, unfortunately, my audio was really bad, but you could tell she was mad. She was very, very angry. And I got the transcript and she was like, you guys need to work this out. I'm not here to be a kindergarten teacher, which was her exact words. So, but I do think I'm going to see more and more mass arbitration matters. It's becoming, I think, a little bit more of a business model for a lot of plaintiffs firms. So, in terms of what I'm covering like right now today, there are a number of PCB trials against Monsanto up in Seattle right now, King County Superior Court. It is very specific to Washington law there. They've lost $1.6 billion in verdicts. Some have been reversed or lowered, but there's a big argument next month in the Washington Supreme Court in which Monsanto is going to argue some key issues in all of the trials that have led to these verdicts that could wipe all of them out depending on how the court rules. It's an interesting case because it talks about PCB exposure from products that were made many, many decades ago. And it was in a school where the teachers and the parents and the kids are all suing Monsanto later, like today. Another really big hot area is these cases involving infant formula. This is 3 trials last year. 2 of them were surprise verdicts, 495 million and 60 million, and one was a defense verdict. And this is a really big area because there are 2 manufacturers of this product. It's an infant formula that you only give to premature babies in the hospital. And it's being alleged that it's causing a gastrointestinal illness called NEC, which I don't know what that, I mean, I know what it stands for, but I can't remember off the top of my head. It's very hard to pronounce, but it's an illness that causes severe problems or death. And so it's got a lot of potential impact because those 2 companies make all of this product. So that's going to be more trials this year against both those companies. And I think that's something that's definitely going to be followed. And then this is my my case that never seems to go away is Johnson & Johnson's talcum powder litigation, which seems like everybody's involved in. The latest is that there is a bankruptcy hearing on February 18th in Texas. And they call it a hearing, but they're also referring to it as a trial. So it's 2 weeks of this U.S. bankruptcy judge, Christopher Lopez in the Southern District of Texas. He's going to make some decisions about whether to dismiss the case. This is another bankruptcy. Some of the same arguments, but some are new. Johnson & Johnson's dealing with allegations of voting irregularities because they went out and reached out to tout claimants for support of a $10 billion bankruptcy plan. And the plaintiffs, some of them are arguing that the voting wasn't proper. So that's also going to come up as well. It is the 3rd bankruptcy for Johnson & Johnson, but it has a lot of distinctions. It's a different judge. It's a different subsidiary that filed the bankruptcy. And it's a different state. It's in Texas where the Texas two-step, the merger that's causing a lot of controversy in Congress, actually happens where you can actually get that done. So it'll be interesting to see how that ruling comes out. And then meanwhile, those are ovarian cancer and gynecological cancers. There are mesothelioma cancers involving Johnson & Johnson's talcum powder trials that are going on. And I'm not sure, my colleague just wrote this story, but there was a trial in Pittsburgh where the jury issued a defense verdict for Johnson & Johnson and then awarded $200 million in punitive damages to the plaintiff. And, and I'm pretty sure this is going to end up on appeal because it sounds like maybe the jury was confused. But I mean, lessons in verdict forms, I guess. I don't know. But there's going to be another trial also in LA Superior Court as well. So those are continuing to happen. And then, one other area that I'm sure you guys are very familiar with is litigation finance disclosures. Many courts already have this, but there is a federal rulemaking committee that in October decided to take this up. And if they actually, it's going to be years, but I mean, if they actually do make some kind of federal rule, that will be really big news. And that would be for civil cases and class actions. And then I just wanted to finally end with like things that I'm looking for in the future, things that I'm paying attention to going forward that might interest you guys. One area that I hear constantly about, especially in the last year, has been claims fraud. I don't know how familiar anyone has been with this, but in some really high profile cases, there have been people using bots and AI to make fraudulent claims on class action settlements. And so there was a big company called ClaimClam that got involved in the Juul settlement and in the Cambridge Analytica settlement with Facebook. And they made the claim that they were making things easier for class members because if they could do all the legwork of the claims process, then they could, help them out. But they did it for a fee. So the judge was not very happy about all of this. Neither judge was. And there was a lot of question about how is this, I don't know, there's things about like click farms, there's all sorts of crazy stuff going on out there. And claims administrators are having to be at the forefront of that. So that's a very interesting area, especially with technology, what people are able to do these days. And then another area that, if you're talking about really high stakes trials, I'm not saying this happens all the time, but I am seeing judges discipline lawyers on a little bit more regular basis. And I think what's going on is the lawyers are kind of pushing the envelope, and not that they didn't do that before, but I think some judges are stepping in and disciplining them. And so an example of this was Abbott's lawyer in one of the infant formula trials, I guess violated a pretrial order during a cross-examination. So the judge disciplined him by preventing him from presenting closing arguments. And he was the lead defense counsel. And so that was kind of damaging for Abbott. They still won the trial. But I also saw this with Monsanto's counsel. The judge said there was like severe misconduct and then declared a mistrial in a Roundup case. So that is happening in really high stakes where everything is like on the line. I do see that happen with judges, especially in state courts. But the plaintiff's bar has its own disciplinary issues as well. I'm in California where we just went through the Tom Girardi scandal, and I did cover that trial. He was a very, very prolific and very well-heeled plaintiff's lawyer who stole $15 million from his clients, according to a jury that convicted him last year. And, you know, he's, the question then is with mass tort settlements, could a judge have stepped in and done something about it? Where was the bar? Where was the bench? What was happening? And why did he get away with it for 20 years? So, you know, I see on both sides, and I do cover these issues, what's happening, especially with really big names. And I mean, that's kind of most of what I cover. There's a whole lot more. Some of the things I'm watching in terms of specific class actions are, I see, we actually have a publication called law.com Radar, where we track incoming complaints that are filed. And some of the ones that we see are these pricing lawsuits. So they're retailers that write, you know, this is a discount, this is a sale price in red, or they strike through the old price, here's the new price. And the lawsuits say there whatever was an old price, you guys are just making all this up. And it usually involves something that people don't buy very often, like a mattress or something like that. So I see a lot of those coming in, especially in state courts now. And then in the mass tort world, I'm sure you've seen the TV ads, but Depo-Provera is an injectable birth control that's being linked to brain tumors. And the JPML actually heard arguments this morning about that case and whether it's going to get MDL'd. So that's another one that I'm following, but happy to talk afterwards. And I did want to say a very thank you for inviting me to this. I really do appreciate it.
Amanda, real privilege and honor. I start my day usually by opening up my iPhone and reading your column, and I would commend it to anybody. I think it's some of the best writing on class actions in the United States. So in our remaining time, Jen and I would like to give you a tour of the class action world. What we've done is distilled the last 12 months over what are the 10 things that we think corporate counsel ought to know. What are the 10 key trends? And this book is all about how to distill information, statistics in a manner to afford our clients a look around the corner. What's coming down the track? What ought to be important to you when you make your decisions? So that's what we're all about. So we're going to flip back and forth through those trends. I'm going to take 5. Jen's going to take 5. The first one I'm going to take on settlement numbers. And this year, the key takeaway was the 3rd year in a row where settlements topped $40 billion. The plaintiff's mantra is file, certify, monetize. The defense mantra is fracture, crater it, make it go away. So what happened? Well, last year, the top 10, these are only the top 10 settlements in each of these substantive areas added up to $42 billion. The year before, 51 billion. The year before that, 66. So you have basically $160 billion in transfer of wealth from corporate America to plaintiffs over the last 36 months. For those with a calculator, that equates to 4.4 billion per month, 147 million per day, 6.125 million per hour, and $102,000 per minute. So in the 20 minutes when Amanda was talking, over $1 million worth of settlements were paid by corporate America today to settle these sorts of cases. In a word, this is unprecedented. The zone where corporate America now operates in this sort of area. We've never seen anything like this before. Another way to look at it is the number of billion-dollar settlements on this slide. There were 10 in calendar year 24. There were 9 in 23, 15 and 22. So 34 separate billion-dollar settlements over the last 36 months, the most unprecedented number of billion-dollar settlements in the history of American jurisprudence. So privacy settlements way up off the Richter scale. Data breach almost doubled. Labor nearly doubled. So what's the bottom line? I think companies, the bottom line is companies are now operating in a new normal, a new environment, an environment of enhanced risk. The price of litigation is going up. It might be because of social inflation, might be because of angry jurors, might be because of COVID. But I know when I go into mediations, what I'm facing now in demands are demands that are exponentially larger than 3 years ago because of this pace in this history of settlements. And so if you look on your iPhone, kind of what you see on social media is this mantra of where is mine? Plaintiffs' lawyers advertising the settlements, people talking about new lawsuits, you have people thinking about their rights. It's fueling the filing of more lawsuits. And then they have something what I call the Cabo effect. Last month, I was invited to a plaintiffs' convention as the sole defense lawyer to talk about what it's like to be on the defense side of the case. 2 full days, 1,000 plaintiffs' class action lawyers thinking about new innovative theories to identify vulnerabilities at companies that they can exploit and sue over. So these big, huge settlements are creating an environment where the plaintiff's bar is putting their best and brightest forward, innovating, trying to find new ways to sue, to file, certify, monetize. So for me, that's the number one takeaway over the last 12 months. Next slide, please, over to Jen.
Thanks, Jerry. So our second trend relates to class certification. So class certification, as you all know, is really the holy grail of class action litigation. A plaintiff doesn't represent other folks just because she says so, and she doesn't represent other folks just because she files a complaint that says class action. Instead, the case is the plaintiff. It remains limited to the plaintiff until a court issues an order certifying the class. It's that ruling that allows a plaintiff to increase the size of the case, sometimes exponentially, in terms of the persons involved, the claims at issue, and importantly, the damages or exposure presented. As a result, we closely monitor these motions for class certification, and we closely monitor rulings on class certification. And it's one of the things we talk about in the book. It is really one of the best indicators in terms of the plaintiff's success in using the class action mechanism effectively to leverage these settlements that Jerry was just mentioning. Let's look at this next slide. So in 2024, plaintiffs succeeded in certifying class actions at a very high rate. Across all major types of class actions, courts issued rulings on 411 motions to grant or deny class certification. Of these, plaintiffs succeeded in obtaining or maintaining certification in 262 rulings. That is an overall success rate of about 64%. Meaning that plaintiffs succeeded on 64% of these motions. Comparing that to what we saw in 2023, courts issued more rulings, 451, and granted more motions, 324, and the overall certification rate was 72%. So defendants did a bit better in 2024 than they did in 2023. There's a bit of a rub to that though, and here's what it is. Although courts granted certification at a lower overall rate, plaintiffs were able to obtain certification at a more consistent rate across substantive areas. So we saw in 2024 a low of 33% in the RICO area, as you can see on the slide, and a high of 86% in the Warren area. That we can contrast that with 2023, where the numbers ranged more drastically from a low of 14% in the data breach area to a high of 97% for securities fraud. So that year-over-year compression, what does it suggest? Well, maybe plaintiffs are being a little more selective relative to the cases that they choose to pursue through class certification, particularly at that low end. We're seeing that a bit in the data breach area, where plaintiffs only certified 14% of cases in the data breach area. In 2023, filed fewer motions for class certification of data breach cases in 2024, but had a much higher success rate. So in essence, plaintiffs seem to be a bit choosier in terms of what they did in 2024, in terms of where they were pursuing class certification, suggesting they may be getting a little wiser with their investments and settling out these lower likelihood cases prior to getting to the class certification phase. Let's look at the next slide. So our next trend relates to privacy class actions. So the plaintiff's class action bar has continued to invest in the privacy class action space. Over the past year, this investment really generated a multitude of filings, making privacy one of the hottest areas of growth in terms of activity by the plaintiff's bar. It's technology, it continues to evolve, and it continues to inspire and provide a lot of raw material for these claims. Two of the areas I want to touch on in particular in the privacy space include litigation involving biometric technologies, mostly brought under the Illinois Biometric Privacy Act, or BIPA. And then second, litigation regarding website advertisements, website advertising technology, or ad tech for short. That's much easier to say. Let's look at the next slide. So in terms of BIPA, in 2024, there was a major development. The Illinois General Assembly limited the damages available under the statute. Rather than allowing the per scan damages, the Illinois lawmakers limited damages now to a per person measure. So that was a welcome relief for the defendants. Unfortunately, though, per person damages still remain fairly sizable and pretty much on par with the damages available under a lot of other privacy statutes. So whereas we saw the growth rate in BIPA filings slow a bit in 2024, the filings remained fairly robust, particularly in comparison with prior years. You can see that on the middle chart here in blue. Plaintiffs filed 427 lawsuits invoking the BIPA in 2024, compared with 417 in 2023 and 362 in 2022. So the growth stayed relatively flat, but it did go up a bit. Now turning to the second area I wanted to touch on, ad tech. So ad tech represents another key area of growth. Again, it's really, these are lawsuits directed at website activity tracking tools. Those tools are nothing new. They are ubiquitous. They are on most websites, but they are fueling lots and lots of lawsuits. We saw hundreds of lawsuits filed over the past year, alleging that these tools secretly share users' private information with companies like Meta and Google and other online advertising agencies. Plaintiffs in bringing these claims typically seek to invoke a statute that provides for statutory damages so that they can assert that hundreds of thousands of website visitors times statutory damages of thousands of dollars per claimant yields billions of dollars in exposure. The VPPA, or the Video Privacy Protection Act, is one of these statutes that we see invoked in this space. In cases where websites contain video and ad tech is transmitting video viewing information, plaintiffs often invoke the statute, which has, again, statutory damages in the thousands, up to $2,500 per violation. It also provides for attorney's fees, making this an attractive statute for the plaintiff's bar. The orange bar chart there represents the filings under the VPPA. Plaintiffs initiated more than 250 VPPA class actions in 2024, compared to only 137 in 2023, really reflecting the growth in use of that statute. In sum, this privacy area is one where we are continuing to see that creativity on the part of the plaintiff's bar. The plaintiffs are forcing courts to confront more matters of first impression in this area, really leading to this patchwork quilt of rulings. And we expect that that's going to continue to drive filings in 2025.
Next slide is our fourth trend, and it's arbitration. Whenever I see this slide, I think of my son. Graduates from college, gets his first job, never calls me other than when he needs help, calls me during orientation. Dad, should I sign this form? My employer said I can work here, but I got to sign this arbitration agreement. Heard you talk about those all the time. It means I can't be in a class action, right? I said, you better sign it if you want that job. Best way to stop a class action is not allowed to occur. Arbitration agreement's still the best tool to eliminate, limit, fracture, manage that sort of risk. Still a very, very vibrant, robust defense. Next slide, please. However, what this next slide will show is there's a chink in the armor. The defense rates were up around 66, 67% the last 2 years. This year, down to 54%. What's going on? Plaintiff's bar is a lot better at selecting cases to attack situations where the person didn't see, didn't sign, didn't assent to the arbitration agreement. They're picking and choosing their spots, trying to get around them. The difference between a class action that goes away pursuant to a motion to compel arbitration, $20,000, compared to one that gets around it and goes forward, can be $1 million. These are critical high stakes motions to be won. Employers still doing well, companies still doing well, but definitely a chink in the armor. What are those factors? Well, one is statutory. Congress passed some laws. For instance, sex harassment claims can't be arbitrated anymore. A lot of imaginative, innovative plaintiffs' lawyers loading up a class action with a sexual harassment claim to use that as a tool, as a sword rather than as a shield to get around arbitration. And then the Supreme Court, which we'll talk about in a little while, with what's known as the transportation worker exception in the Federal Arbitration Act, where arbitration agreements cannot be used. So this morning, there was a great ruling out of West Virginia. It said coal miners who load coal onto railroad cars that ship the coal weren't really transportation workers. Their arbitration agreements should apply. Class action is dismissed. So a lot of litigation in this area. I'd say the takeaway would be, if you have one, look at it, tweak it, review it, make it as tight as it can be. If you don't have one, think about it, because it's still the #1 risk management tool. Fifth trend. This is a big one. DEI and ESG initiatives. I represent a lot of major law firms in the United States. Ever since the Harvard decision in 2023, where the Supreme Court said certain types of preferences may be illegal, clients have been on the receiving end of attorney demand letters. You need to do away with this scholarship, this internship, this program about a bonus structure based on achieving diversity initiative. Starting to see EEOC charges filed over that. You're seeing the Supreme Court accepting for decision a case called Amos that is going to clarify the burden of proof in reverse discrimination cases. In October of 24, we had our first reverse discrimination class action trial, where a high-tech company was found liable for preferring Asian employees and disadvantaging white employees. And now there's going to be a class trial on damages involving about 5,000 workers. So we're seeing lawsuit after lawsuit. And then the world changed on January 20. Just 10 days ago, the president, next slide please, issued an executive order obliterating government sponsored DEI programs and saying any illegal ones should be dismantled. So you have a lot of flux, a lot of noise, a government pivot in the last 10 days. You're going to see a new emphasis in the courthouse on reverse discrimination claims. All employers, all companies probably now are at risk in terms of the way in which their programs are written, how they're presented, how they're represented in marketing. We've seen securities fraud cases, consumer fraud cases. So the watchwords would be vigilant, be flexible, get ready. This is going to be a big deal in 2025. Next slide, please. Sixth trend is the Supreme Court of the United States. This is a big deal. Next slide, please. Supreme Court often wades into the area of Rule 23 law, class action decisions. I like personally to view every decision in two boxes. It's either a door opener that issues a ruling that makes it easier for people to sue, to procure damages, or a door closer, easier for a defendant to defend claims or shut them down. There were at least 4 big claims this year, 4 big cases that were issued. Most of them were 9-0 decision. Big one in the class action area was the Loper-Bright, which eradicated what was known as the Chevron doctrine that deferred to administrative interpretations of law. And so you're seeing now in wage and hour cases, plaintiffs' lawyers can no longer rely on Department of Labor regulations because a defendant can attack them under Loper-Bright. We had a series of arbitration decisions in Smith and LePage and Coinbase about judges, arbitrators deciding who should decide the parameters of an arbitration clause, whether a case should be stayed. They were all what I think are door closers, utilization by employers of various decisions to shut things down, other than the Bezonet case, which was on the worker transportation issue. And now you have a lot of arbitration decisions fighting over, am I in the industry, am I not? Hence the West Virginia coal case we talked about this morning. 2 days ago, Monday, the Supreme Court accepted for review a case called Laboratory Corporation of America versus Davis. And it's going to decide a very technical procedural issue that will have a bottom line, huge monetary effect on class action litigation. Must every member of a class suffer an injury, or is it okay just for the named plaintiff? If the Supreme Court goes the way of the defense, Jen and I have a brand new motion to dismiss that we'll be using in every class action, and it will make class actions easier to defend. We'll see. We should know by end of June. So watch and listen. Next slide, please.
Let's look at trend number 7. So trend number 7 relates to data breaches. Data breach litigation was expansive in 2024. Plaintiffs filed more data breach class actions in 2024 than they filed in any other year in history, including double the number they filed just 2 years ago in 2022. The growth of filings in this area has really been extraordinary. We are talking about 108 class actions in 2018. That's 6 years ago. In 2024, we had 1,488. That is an increase of more than 1,200% over 6 years. So growth, tremendously expansive. The downside also, or a second downside, is that plaintiffs have gotten better at these cases. They've gotten better at getting through the pleading stage. And I would say, although the roadmap for a successful class action in the data breach space is still very much a work in progress, plaintiffs made progress in 2024 on the class action front. They also got better. As the graphic shows, can we go to the next slide? The class certification rate improved for plaintiffs in data breach cases. It increased from a 14% success rate in 2023 to a 40% success rate in 2024. We also saw fewer rulings, though, as I mentioned earlier. Courts issued only 5 rulings on motions for class certification. Plaintiffs prevailed on 2, yielding that 40% success rate. So given this surge in filings, this is a little bit of a disconnect. The numbers suggest that either there are many, many motions remaining in the pipeline awaiting a decision, or that perhaps the difficulty plaintiffs have faced in certifying these cases over the last 2 years has led them to elect to monetize these data breach claims earlier on, prior to reaching the class certification phase. So either way, defendants are continuing to fund settlements in this area, allowing plaintiffs to monetize those claims without clearing that class certification hurdle. So as a result, we expect that this is going to be a continually growing area, and we're going to see more class action lawyers drawn into this space and more growth in data breach litigation in 2025.
Next slide, please. Our 8th trend is what we call PFAS litigation. There known by the phrase forever chemicals. I think there's an argument that they've caused what are known as forever lawsuits. Next slide, please. This is the #1 attention grabber headline of 2024, largest settlement of the year. Kind of just an astounding number to look at, $10.3 billion. Think about the time, effort, and money of people to generate $10.3 billion worth of money to pay in a settlement. It spiked a measly settlement of only $100 million and an award of attorney's fees. So just think about those numbers and let that settle in. Think about your iPhone and all the people reading about that, thinking about PFAS litigation. I think in 2025, we're going to enter a zone which I call PFAS 2.0. For instance, in the last 30 days, Apple has been sued over its wristwatches on the theory that there's PFAS chemicals in the wristband. Landfills containing PFAS chemicals are being sued. Towns, private companies that have ownership over what are called toxic dumps. Coca-Cola has been sued for PFAS ingredients in its fruit drinks. Hershey chocolate company has been sued over its Kisses and Kit Kat bars for PFAS chemicals in those candies. And drinking water contaminations is upon corporate America and municipalities throughout the country. 7 states in 2024 issued new regulations, new duties, new obligations with respect to reporting, giving notice of PFAS chemicals. So suits over product representations, misrepresentations, reports to board, advertising, and then the raw chemical itself. So when I was down in Mexico at that plaintiffs convention I mentioned, 50% of it was about PFAS litigation and going to the next level. So look in 2025, more lawsuits, more innovation, more causes of action, and lots of money at risk. It's going to be a problem that's going to be with us for a while. Next slide, please.
Let's look at trend number 9. California remains ground zero for PAGA representative actions. So PAGA, the California Private Attorneys General Act, inspired more representative lawsuits than any other statute in America over the past year. The so-called PAGA reform efforts, or PAGA reform legislation passed by California lawmakers, really did little to nothing to curb interest in these cases, which we saw continue to get filed on an unprecedented level, as most likely because it's one of the only viable workarounds to these workplace arbitration agreements that we were talking about earlier. Let's look at the next slide. According to the data maintained by the California Department of Industrial Relations, the number of PAGA notices filed with the LWDA has increased exponentially over the past 2 decades. The number grew from 11 notices in 2006 to 1,600 in 2013, and then experienced about 3 more sizable jumps, 2014, 2018, and 2023. Each of those jumps coincides with a significant shift or ruling in the legal landscape concerning workplace arbitration. Each of those shifts either intensified the need to look for a workaround or strengthens PAGA's immunity from arbitration. In 2024, as you can see from the chart, notices exceeded 9,000 for the first time. That is an all-time high. The plaintiffs filed more than 9,464 PAGA notices in 2024. That represents a 22% increase over 2023 and a whopping 86,000% increase over 2006. Given the technical requirements of California wage and hour law, coupled with those potentially crushing penalties that are available to successful plaintiffs under PAGA, we should anticipate that we're going to see the continued growth of PAGA lawsuits in 2025.
Last trend number 10. This is about government enforcement litigation. These look, feel, taste, and on the receiving end are just like class actions. I like to say it's like holding a tiger by the tail. Very, very difficult set of circumstances. In the 42 years I've been a lawyer, I've seen ebbs and flows in governmental enforcement litigation. And so next slide, please, will show you that in the last year of the Biden administration, number of lawsuits were down. Somewhat counterintuitive that less lawsuits were filed, but both at the EEOC level and the Department of Labor level, employers were sued less by the Biden Department of Labor and EEOC than before. Yet recoveries were up. The EEOC, for instance, recovered over $700 million. So then something happened called January 20. And in the last 10 days, everything has been turned upside down and sideways, and I think will remain that way in 2025. We have a whole new kettle of fish we're dealing with insofar as our president removed various officials in policymaking and authority positions at the Department of Labor, at the EEOC, at the NLRB. I think on the theory that if you remove them from office, no one will have a quorum, the business won't be done, and that will shut down some government enforcement litigation. What we're going to see are lawsuits, probably going to be sorted out in the court as to who in the world is in charge and whether or not a president can do that. But what it's going to force is a rejiggering, it already has, of priorities and what is the official or unofficial stance of these governmental entities. So for the time being today, to be changing, and everybody viewing the scorecard is a slowdown at least this month. Who knows what it'll be next month, but I see a lot less predictability, a lot more change. And the one thing I have seen in the 4 decades I've been doing this is whenever the government, as a watchdog, starts slowing down, the private plaintiff's bar rushes into that void. So there's not going to be less litigation. There's not going to be less people with companies on the radar. It just means that the watchdog's going to change from maybe the government to the private plaintiff's bar. So other than that, not a lot went on in 2024. Those are your 10 trends that we think are important. Next slide, please. Anyone who wants the book, it's free of charge. We'll give pop quizzes at the end of the cocktail party. My partner, Tom, is going to give our concluding remarks, but we really appreciate everybody's attention and hope that we gave you a quick tour of what's important in the world of class action law.
Well, that was tremendous. Thank you so much, each of you, for sharing your insights. For the rest of the group, thank you for joining us today for the review book launch. Thank you for our guest speaker, Amanda, for joining us today and your thoughts and insights. Please know that you can follow our daily developments on the class action litigation that impact your businesses by subscribing to our class action blog. And we hope to see you at the next Duane Morris event. We'll be outside. And for those who are online, many of you, thank you so much for joining us. We have questions. The code for CLE credit. Somebody in the back is going to help us with that. So we'll point you right in the back in that corner. She's got her hand up. She'll help you with the code for CLE credit. That is good for all of us who need those to keep those credits. Thank you. Anything else before we wrap up? Thank you, and a big hand, please.